on to Mr. Jackson. And
Thanks, Tim. Can I ask you to put that slide with the VA
Yes.
compensation back up? Absolutely. About 3 slides ago. There we go. That's what. Neil was kind enough to invite me to come and speak today, and he asked me to talk about how I got into representing veterans, what that entails on an ongoing basis, and what some of the common types of issues that we see, and to leave room at the end for some questions, so we'll do that. The way I got into representing veterans is really sort of a back door. I started out my practice doing a very general practice, lots of litigation, did a lot of court-appointed criminal stuff. And if you do court-appointed criminal stuff, as you may know, you end up doing a lot of appeals because you mostly lose a lot. So I ended up doing some appeals, and I was lucky enough to have a case that went very well for me in '81, the State v. Anaya, and got me some attention as a appellate lawyer. And after that, a few years later, I did a case in '91, Bolino, that went to the First Circuit, and that got some attention. And as a result of that, shortly after that, a lawyer here in town got in touch with me and said, gee, I've got somebody who wants to appeal, and it's to some court in D.C. that I don't know anything about, and do you want to do it? And I said, sure. You know, I thought I knew all about appellate law, and so I just said that was fine. And I took on this case, and I'm scratching my head saying, gee, never heard of this court before. And so I started looking around, and lo and behold, I'd never heard of it before because it didn't exist before. They just created it. And what happened is in 1988, Congress passed a statute that created what was then called the Court of Veterans Claims, Court of Veterans Appeals, excuse me. And it was the first time that the VA's decisions on things like compensation and pension had been made reviewable in the courts. Now, that's sort of an odd concept to lawyers. We think of agency decisions as being generally reviewable in the courts, but up until '88, the VA pretty much was protected from court review. And so they had this kind of insular little system of their own, supposed to be kind of paternalistic, and nobody really got to challenge it very much, although there are a few kind of, if you dig back historically, there are some sort of odd cases challenging the VA on various things, but not routine review of their administrative decisions. And for those of us who go to law school, you know, we tend to think that administrative decisions are routinely reviewable. You know, the APA have kind of a similar system of review for Social Security decisions. That stuff's all reviewable, but the VA was not. And so in '88, Congress passed the statute, set up this court, and it took them a while, obviously, to set up the court, but they issued their first actual decision in December of '89. And if you go back to the very beginning of the Veterans Appeals Reporters, you'll see that Volume 1 starts with the decision in December of '89, goes up through into '91. Anyway, I got this call in '91, and I took on this case, Mrs. Smith, and if you are bored sometime, you can go and read it to 2-Vet App, 241. It's sort of an odd case. It's about presumptions. There's a presumption that if you get hurt or killed while you're on active duty, that it's automatically service-connected and you're entitled to benefits and so on. Except if there's willful misconduct, and in this case they were arguing willful misconduct, and we had a big fight over how the presumptions apply. And anyway, Ms. Smith got a remand and went back for another try at her benefits. And that's how I got into the thing. But it was sort of fascinating. I literally had not heard of the court, so I had to figure out where it was and how you got in touch with them. Then I had to apply to become a member of the bar of the court, and we went through all that. But then we started trying to figure out how do you brief this case. Well, that's very interesting because there were no precedents. You know, they had literally one volume of precedents, and none of them talked about willful misconduct. So we went out and dug around, and we scared up some JAG opinions that talked about what was willful misconduct. we dug into writing over that talked about how presumptions work, and we put this brief together and had an oral argument and eventually won and got remanded. So that's how I got into the VA stuff. And I liked it. I thought it was kind of interesting, and there were some sort of oddball issues, and nobody knew much about it, so it wasn't like I was any further behind the curve than anybody else. So I started doing it, and now I've been doing it for some 20-odd years, and if you go on the court's website and put up my name, you'll find a couple hundred cases, most of which are not reported. And the reason that they're not reported is in one red app, you'll find a decision called Frankel. And Frankel says, gee, we have the right under the statute, unlike most appellate courts, to do most cases by single judge decision if we want to, instead of taking the time of 3 judges and clerks and so on. And so for efficient processing, we're going to say that anytime it's simple, we can do it as a single judge opinion. And so you will see over the years that most of the decisions coming out of this court are single judge opinions. They're non-precedential. They are reported, but they're non-precedential. And so you can really only use them for ways to figure out what kind of argument you might want to frame. You can see what some single judge said about it. And obviously, if that was persuasive to him, it may be persuasive to a panel or to the other judge that you're in front of. And so that's one of the ways that you can work with these things. But turning, if I may, to Neil's sort of second topic, what the work entails on a daily basis, let me kind of walk you through the process a little bit, because it's not intuitive, believe me. But Neil was explaining to you that when you get a decision from the Veterans, the Department of Veterans Affairs now, it used to be the VA, but the Department of Veterans Affairs, you get one of these little notices. And this notice says that if you're unhappy with the result, you can appeal, and that the appeal from the regional office is to something called the Board of Veterans Appeals. And the Board of Veterans Appeals is this board in Washington that has review authority over individual veterans benefit decisions in most of the areas that Neil had up there earlier. You can appeal over things like whether you're entitled to payment of certain medical bills, whether you're entitled to GI benefits in the loan area, various other things. But primarily, the issues that go up are compensation and pension, which is why you have this compensation thing up here. But the process is, you make an application to your local office, your local regional office with the VA. And every state has at least one regional office. Some big states have more than one. The agency makes a decision, typically on the paperwork. It's very rare for anybody to actually have any sort of hearing at that level. And then, originally, you went right from that decision on an appeal to the Board of Veterans Appeals. The VA has now instituted an optional intermediate step that they call the Veteran Review Officer, Decision Review Officer process. And that's intended to have a senior person look at the decision, look at any additional evidence you have, to try to resolve it at the local office without sending the case to the Board of Veterans Appeals, which is always backlogged and has huge numbers of cases waiting, and they're trying to keep those down. So they have the initial decision. If you lose, you go to the Decision Review Officer. If you lose, you only can go to the board at that point, to the Board of Veterans Appeals in Washington, or you can also go back and reapply if you want. But once you've gotten to the board level, for those of you who know historically, there's an alumnus from UMaine who was chairman of the Board of Veterans Appeals for a while, Charlie Cragen. And Mr. Cragen, among other things, besides getting a lot of UMaine graduates employed by the Department of Veterans Affairs, also got the title changed. He wanted everybody to be a judge, so the members of the Board of Veterans Appeals now are veterans law judges. And that's intended to give them kind of commensurate status with typical federal government administrative law judges. And so at the board level, you get another shot at a decision. And again, this is an odd body from a lawyer's point of view. It is both a reviewing body and an initial fact-finding body. So you can present live testimony, you can present evidence, you can do anything that you could do before a typical administrative hearing officer, but he is also sitting in a review capacity of the decision below. So it doesn't make a lot of difference, because since they're doing everything in terms of taking new evidence and so on, ultimately it's basically a new decision, and you get to make those arguments. The board does decisions three ways. You can go to their office in Washington and have a hearing. You can have a video hearing from somebody in their Washington office linked with the regional office where you are, at Togus, for example, or Manchester, New Hampshire, or White River, Vermont, or wherever you happen to be. Portland, Oregon, if you happen to be there. The third way is they have what they call travel board hearings, which is to say members of the board travel to the various regional offices around the country, and you can have a hearing with a live person face-to-face. We found that seems to work better, but you can get hearings any one of these three ways. And then if you lose, you get back to the body we were talking about at the beginning, the court in Washington. And one of the unique things about it is it's an Article I court as opposed to an Article III court. And so all the people are appointed for 15-year terms, kind of like the tax court, the claims court, and so on. And those folks sit primarily, as I said, individually, but they also sit as panels of three, or en banc as the entire court. There are currently 7 judges, and the most senior guy is automatically the chief, unlike the Supreme Court, where you can be appointed as the chief. Whoever has seniority at the Court of Appeals for Veterans Claims, they're the chief. And so that's how that part works. But the court typically hears oral arguments in maybe 2% of their cases. In 92, they had something like 1,900 cases filed. This year, I looked just before I came, and they're up to about 3,300 new cases filed so far in 2011. So they'll probably hit, something close to 4,000 by the time they close their filings at the end of the year. And most of those get disposed of by single judges, but there are a few every year that are done by panels, and once in a rare while you get an actual en banc decision, but those are very rare. But what we do day to day in these cases, most of the time, is simply to assemble the facts. There's a tendency in law school, you read these cases and you sort of take the facts as given. Well, obviously, somebody had to get those facts there in the beginning. And the thing that most non-lawyers have the most trouble with is understanding how to analyze what facts are going to compellingly demonstrate their claim. And particularly in these sort of, typically these compensation claims are about injuries or disease. So you're looking at some kind of a medical issue, and you're looking at, again, a relationship between service, because it has to be something that happened while active duty or was made worse by active military service. And that's actually not quite broad enough. It essentially is anything that was caused reasonably directly by your military service. For example, I'm sure that some of you have heard of Agent Orange. Agent Orange is this wonderful stuff that Dow Chemical made that they spread all over Vietnam during the Vietnam War. And it turns out that if you get exposed to that stuff, it can do bad things to you. Can't even do bad things to your kids. And so there are a whole series now of diseases that are presumptively service-connected as caused by Agent Orange. But there are lots of other things that there's a real fight over whether it was caused by Agent Orange, or conversely, if the person was not in Vietnam but claims exposure to Agent Orange in another setting, handling the stuff on shipboard, being exposed to it at Fort Drum when they tried it out, things like that, then you have a different issue about proof of exposure plus the proof of the service connection. So many of these cases turn primarily on obtaining the medical documentation to show that the injury or disease is related to service, because what you have in a lot of these cases, you have somebody coming in and saying, gee, I was in the service, I hurt my knee, now I have arthritis in my knee, and the VA will say, you know, that's fine, we can see in your records that you hurt your knee in the service, we can see in your records that you have arthritis in your knee, but there's no medical evidence saying that one caused the other. And in fact, we've read your medical records, and after you hurt your knee, you complained about it for 30 days, and we never heard about it again for the rest of your entire service career, and we don't think it has any relation to your current arthritis. So the place that most veterans have difficulty in presenting their own claims is making the connection between what happened to them in the service and whatever medical condition they're currently complaining of. And some of these things have special requirements, if you will. There's a large body of post-traumatic stress disorder claims related to service in one way or another. And for a long time, there were some very narrow, very restrictive rules about proof of exposure to a stressor sufficient to cause PTSD. I'm happy to say that the VA, with a little prodding politically, has now made it easier for veterans to make that connection. But there are still some very difficult special situations where proof of the stressor is problematic. The ones that we run into most commonly are issues of assault, either physical assault or sexual assault in the service. You know, I'm not a veteran, so I don't speak from any personal experience, but I can tell you that if you look at the case law arising from the court, or you look at cases at the board, board decisions, for example, are posted online. You can actually go and look at board decisions. They blank out all the identifiers about, you know, who the veteran is and so on. But you can go back and look at years worth of Board of Veterans Appeals decisions if you want. And you'll see that there are a lot of sexual assault cases, sexual assaults against both men and women. And those cases are very difficult to prove because typically people are embarrassed. They don't want to go and tell their commander that this happened. You know, it often happened off base under circumstances where they were perhaps intoxicated or whatever, and they're just very embarrassed to even talk about this to people. Sometimes they don't talk about it to anybody for years, and so it becomes quite problematic to prove the relationship. But those are the kinds of things that we do day to day. We spend a lot of time developing the facts, particularly the medical relationship facts, on individual cases. Obviously, we also do hearings. We go to hearings at the regional office here at Togus. We do live hearings with traveling boards. We do video hearings. We travel around the country and do them. I've just been told that I had the great joy of going to Oklahoma soon. But in any event, we do these hearings. We do them all around the country, and they're fairly simplistic presentations usually. Typically, the presentations at the board are not really about complex legal issues. I mean, the cases may have complex legal issues, but the presentations are typically about fairly simple, factual issues. Typically, it's the veteran testifying. Sometimes we'll have other people testifying on their behalf, but most of the evidence beyond the veteran's testimony is stuff that's submitted in writing, letters from the doctor, affidavits from somebody who was there at the time something happened, buddy statements they're called in VA parlance. So most of what we do is really about gathering the evidence to demonstrate that this problem that happened in the service led to this medical problem that the veteran currently has that should be rated at this level in the VA's compensation system. The compensation system is quite different from most other disability adjudication systems. At Social Security, for example, either you're disabled or you're not. It's very simple. It's black and white. You're in or you're out. The VA, on the other hand, has a very complex, staged system where you can be service-connected anything from 0% up to 100%, and it may vary over your lifetime. It may vary even in short periods. For example, you have a 20% service-connected foot problem, but it requires surgery, and you have to be hospitalized for a couple months. You may jump up to 100% for that period while you're in the hospital, and then back down to 20%. So you see lots of fluctuation in the levels of disability, and the corresponding levels of benefits go from quite modest to upwards of a couple $1,000s a month, depending on the level that you're at. So our goal in each of these cases is to establish entitlement to benefits and then to establish the maximum level of benefits that each veteran client is entitled to. Most of the time, if somebody has a serious service-connected problem, we're ultimately going to end up with what they call unemployability or individual unemployability, or TDIU, which stands for total disability based on individual unemployability, which is a special thing that the VA does that lets you get paid as though you have 100% disability, even if you actually are at a lower percentage rating, if your service-connected disabilities prevent you from working at any significant level. And so, in every case, we're going to look at what can we establish disability entitlement for, what's the maximum rating we can get the person, can we get them multiple ratings if there are, you get a rating for the left leg, you get a rating for the right leg, and the VA has this incredibly complicated system where they don't add up the amounts of compensation. Instead, they sort of inversely geometrically multiply them so that a 10% rating and a 10% rating and a 10% rating and a 10% rating don't add up to 40%. They probably end up at 30% if I remember the chart right. But there are different, different combinations so that you get these odd things. Anyway, so we're looking to maximize the benefits, and then, if possible, we want to get the person to 100% either based on their particular disabilities or based on individual unemployability by demonstrating that even though they don't add up to 100% on the VA's chart, the combined disabilities are so severe as to preclude the person from employment and thus entitle them to benefits on this other method. So we do a lot of that. Neil asked me to comment on the most common issues that we see. And keep in mind that we see a skewed set of claims. People don't come to me unless they've been turned down with the VA. So claims that are fairly straightforward and fairly simple just don't come. The VA will accept those, that's that. So the claims that we see tend to be claims that are either legally complex or factually complex. And typically it's factually complex. There are some legally complex issues. Neil was talking about who's a veteran. You know, that sounds really simple on the surface, but if you ever go and read a case called Biggins from the court, you'll come away wondering why you thought it was simple. There are some odd things, like being in the National Guard, for example, doesn't automatically entitle you to be a veteran for court purposes under certain circumstances. It just gets very strange. So there are some odd legal issues, but mostly these cases are about people not being able to develop the facts. And you know, we routinely end up having to send people to specialists for evaluations to generate the medical evidence to make the connection between what happened while on active duty and the problem that got them. Whether that's a psychiatric evaluation, an orthopedic evaluation, a cardiologist's opinion, you know, that's this kind of stuff that we're working on. And we had one, what I think is a wonderful result recently. We got the board to agree that this gentleman died of stomach cancer, and the board ultimately accepted our experts' position that it was at least as probable as not that his stomach cancer was caused by exposure to the constituent elements in Agent Orange. Stomach cancer is not one of the presumptively service-connected conditions for Agent Orange, but we were able to persuade the board that this fellow's stomach cancer should be related to his exposure to Agent Orange, and got his widow, unfortunately not him, 10 years worth of back benefits for her PIC claim. Yeah, I'm very proud of that one. I think we're the first ones in the country to have persuaded the board to do that. So we've had there are typically these kinds of claims, and as I was saying, the ones that come to us are either legally or factually complex, but usually it's factually complex. Most of these cases do not turn on complex legal interpretation. There are some that do, but that's kind of the exception, not the norm. The Smith case that I started out with has this complicated issue of presumptions, but you don't run into a lot of that stuff. Mostly it's just applying the facts. And I did want to touch on one thing that doesn't show up here. When you talk about the VA, there's compensation and there's pension. Those are not the same thing. And pension is an entirely different benefit, actually, that the VA has that is available only to people who served in what is designated as a period of war, whether it's Vietnam or Korea or the current conflict in the Mideast. And that benefit is available to anyone who is disabled, who served in the requisite period of war. You don't get the same amount of benefits as if it's service-connected compensation, but it is a benefit that's available based solely on disability. You don't have to make the connection that you have to make for compensation between the causation of the condition and service. You just have to have been a service member, you have to have served in a time of war, and you have to be currently disabled and poor, because you don't get very much money. But the VA, you can think of it, if you're familiar with the Social Security system, you can think of it as sort of the VA's equivalent of SSI. So those are kind of the basic things I wanted to touch on. Neil, if I'm right on the time, it's about time for questions?
Yep, absolutely.
Okay, I'll be happy to answer any questions anybody wants to throw out to the best of my ability.